Good morning, Mr. Cole.
Good morning, y'all.
Good. Good morning, sir. Are you Leonard Idleberg?
Yes.
This is cause number 16-25968. It's the MTRP. I feel like we're waiting on, there was a motion for a competency evaluation,
Yes, ma'am. I e-filed the
but I don't see that it's been done yet. It's
been done.
it has, we just
Yes.
don't have a report yet.
It should have been e-filed into the case, Your Honor.
The report?
Yes, Your Honor.
They sent it to you?
Yes, Your Honor.
Oh.
To me, not to you.
Oh,
I mean,
okay.
I certainly take
Who
Mr.
did
Cole's
it?
word for it. but-
Dr. Riggins out of Houston.
Oh,
The court wouldn't pay for his evaluation.
I don't see that it's in here yet.
I do have a copy of it.
Can I see it real quick?
I'll have to send it to your email, Your Honor.
Oh, okay.
Yes.
All this paperless stuff.
Yes, Your Honor.
Finding competent, not competent?
Not competent.
Okay.
Not competent or
Dementia.
dementia?
Dementia.
Because I think there's a legal difference.
Yes.
Yes.
Yes, it was dementia.
Okay. Obviously, we need to take a look at that. I'm going to reset it 2 weeks.
That sounds great.
If you will make sure, it should, if you e-filed it, it should be coming through, but if you'll also just in an email forward that report to Ms. Malfino and
Yes.
and that way you guys can take a look at it, talk and see if there's something that you can work out. I can look at what my options are with regard to that diagnosis, and then we'll see where we are in 2 weeks.
And Judge, just so the court is aware, I spoke at length with his probation officer, Ms. Hunter, last week. Previously, when we were here, I believe back in June, you ordered that he not drive, and you spoke with his wife here
Yes,
in court.
yeah.
Ms. Hunter relays that he is complying with all that. She
Okay.
actually comes to his appointments
Good.
with him, and that everything seems to be
Okay.
going well with respect to that condition.
Okay, well, maybe we'll be able to work it out with just modified type probation. We'll see. Okay, all right, we'll see you in a couple of weeks. Mr. Gertz, you've got David Hatcher. Morning.
Judge, how are you?
Good. How about you?
Well, I'm good. Excited about this week.
Oh, me
Aren't you
too.
excited?
I'm so excited.
I can see it all over your face.
Yeah. Good morning. You're David Hatcher. And this is 24 DCCR 2470. I have a memo that this was the last reset for an announcement.
There's a rejection I just forwarded on, Your Honor.
Oh,
And it's pretty non-specific. Any offer that was going to be made is going to be a pen time offer.
okay. Let me get that
We were
pulled up.
looking for something vastly different than that, so.
All right,
we're on the
so
same page.
you're David Hatcher. And Mr. Hatcher, you're charged with the third-degree felony offense of intoxication assault with a vehicle causing serious bodily injury from September 24th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment could be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection that you've signed with Mr. Gertz that just shows that any offer the state would make would be for prison time and not for a probation. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Right? Anything that you guys are waiting on discovery-wise?
Not that I know of. Discovery.
I'm not aware of anything discovery-wise, Judge.
All right, we will get it set on the next available trial docket. Stay in touch with Mr. Gertz. He'll let you know when you need to be back. Thank you. You're free to go. And Christopher Thomas, Mr. Gertz.
Judge, we'll meet Ashley back for that.
Did she step out? Which way did she go?
This is important, so.
Just have a seat for a second. I'll recall it in just a second.
Thanks, Judge. Sorry.
Mr. Kelly, you've got Donald Owens.
He's present.
Good morning. You're Donald Owens? And this is 24 DCCR 1192. Mr. Owens is charged with sexual assault of a child, set for trial to begin with jury selection next Monday. And what is the announcement?
Restore. State truth.
All right, then I want to make sure that y'all all understand, obviously after today, no plea agreements unless there is something that comes up very quickly that I'm not or y'all aren't aware of. It is likely to be towards the top of the list since the other old one is gone now. So stay in touch with Mr. Kelly. He'll let you know when you need to be back next week. Okay? All right, you're free to go.
Thank you, Judge.
Thank you. See, Mr. Lewis, you have Nquenda, oh, there you are. Nquenda Ales.
Yes, Judge.
Good morning, you're Nquenda Ales.
Judge, you're going to ask me this at sentencing, so I'm going to explain now. The reason it's now a probation offer instead of a pen time offer, which originally was based on his criminal history, because he had done a 10-year stretch for robbery starting in 2014. Really, I'm rewarding him because he's tested clean every time since about this time last year, Your Honor. And he's come to court. He's done what the court's asked him to do as far as trying to hire an attorney. I think he ended up still having Mr. Lewis appointed, but I know that he's done everything the court's asked him. Essentially, I'm rewarding him because he's tested clean ever since September of last year.
Okay, thank you. And your signature. And are we going on count one?
Yes, Your Honor.
Okay, you're Nquenda Ales.
Yes, ma'am.
And will you waive the formal reading of the indictment?
He does, Judge.
Mr. Ales, in cause number 24, DCCR 0478, the state has elected to proceed on count one only. It alleges you committed the second-degree felony offense of burglary of a habitation from February 5th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak up, please.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Ales is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Obviously, you've been doing very well and following all of those bond conditions. Continue to do that, and you shouldn't have any issues. And then we'll see you back at sentencing. You need to stop on your way out of the courtroom today and talk to probation, and she's at that desk right there. Okay? We'll see you back.
Thank you, Your Honor.
Thank you.
You go off.
Yeah, give me that. Mr. Lewis, you have Karis Antwine.
Yes, ma'am.
Good morning. Are you Karis Antwine? And will your client waive the formal reading of the indictment?
He does, Judge.
And I'm guessing there's a warrant for what?
His bondsman surrendered his bond.
Okay,
And honestly, we thought it was something that was taken care of. They had contacted me. I actually got in touch with Mr. Antoine. He spoke with him, but
okay,
Yes, because I talked to him Friday, and
okay. That's good. I just want to make sure. You're good. Okay. And he'll waive the formal reading of the indictment.
he does, Judge.
Mr. Antoine, in cause number 24 DCCR 1878, you're charged with the third-degree felony offense of injury to a child from September 26th of 2023. And how do you plead to that charge?
okay, good.
You either did it or you didn't do it, guilty or not guilty. Are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Antoine is not competent?
No, Judge.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report, and that'll give me more information about you and your case, and then we'll come back later for sentencing. So, with regard to a bond based on the nature of the plea agreement, Mr. Nichols,
I don't have any objection to that, Judge. He has no felony history that I see.
right? Let me look at this affidavit real
The
quick.
charge itself is for hitting a child with a belt over discipline essentially.
Okay. What's the status of that relationship? Do you still live with that child?
I haven't been around him since the case went on.
Okay.
I do see him. I see him with my mom,
Supervision.
her mom,
Okay.
and I really miss my family.
Well, and we'll see how that goes on probation. For now, you're still under that order to have it only supervised, okay?
I understand.
And then you can work up, once you're on probation, hopefully to having, doing the right classes and everything, and that should be lifted. What I'm going to do, Mr. Antoine, is reduce your bond in your case to $1,000, and I'm going to make that a personal bond. So I think that means though that he still has to go, right? Okay, so you're still gonna have to go, but as soon as you get to the jail and they process you, you're going to be released without making that bond that I set because of the bondsman getting off your bond. Okay, makes sense? It's just, but here's the thing. I'm kind of putting myself out there to make sure that you're going to do all the right things between now and sentencing, okay? You have been until then, but it looks like you had some issues at some point communicating with your bondsman. It's very important, several things that you have to do between now and when you come back for sentencing. Once you're released from jail, you're going to get some paperwork today. It's going to have where probation is. You have to go straight to the probation department, okay? If you get released for some reason later this afternoon and it's too late, then you go first thing tomorrow morning. If you don't do that and get that process started for that pre-sentence report, I don't have to accept this plea agreement. So things could be a whole lot worse. Do you understand? If you violate your bond condition and you're around the children or child that you're not supposed to be unsupervised, then obviously I don't have to accept this. Things could be worse. So keep following all of the rules of your bond. Yes.
I have one question. Okay, is it only for that child?
No, I would say at this point, It needs to be all of your children, and then we'll deal with everything when we come back for sentencing, okay? And so that's for everyone, just to make everybody, well, it's not for everybody, it's for me to feel more comfortable until I get the pre-sentence report and I see what all is going on, how many kids you have, where they live, what the situation is, what the recommendations are from probation. So we're only talking about 5 or 6 more weeks.
Listen,
But it is
I really have something important to tell you.
What?
I've been raising my 10-month-old for months by himself. So if I have to give him up, I will, because I need to stop it for my kids.
Well,
He's a baby. He's been with me since, well, like,
who, where's the mom?
we don't talk. Since the case mom, we don't talk like that. Like my mom and her mom, that's when we meet up, but
I think the court's question is the mother of the 10-month-old is the mother of the child in this case?
yes.
So where's the child that was in this case live?
She's with her mom. I don't see them like that. Like we've been separated since I had been arrested, and she stayed with her mom, and I have my own place.
Okay. But it's the same mother of both your children,
Yes, ma'am.
but the baby lives with you
Yes, ma'am.
and the other child lives with her.
Yes. She got 4 other kids live with her. I just got one.
Did you go through anything with CPS as far as they were, I mean, we have an order for some CPS records, but was there anything, did CPS get involved?
I never went through nothing like that.
Okay,
I don't think anything's been provided to us in response to that order.
doesn't
Judge,
look like it.
that
So maybe
should be
that's because there wasn't anything.
Yeah.
I think it was important that I tell you that I have.
No. I would much rather you be honest, but and if you're raising, let me look at something real quick.
No, not at all.
It's just, and just to clarify, the child is, in this case, not his biological child.
Okay. So how many biological children do you have?
3.
No, with her.
Oh, 1.
Just
One with that. Where you, and then the other 2, or where are they?
They're all with her, and all my other 2, they're with their moms.
With their moms.
Yes, ma'am.
So this is the only one you have. So there's no big deal. I mean, obviously, you love your stepchildren, but that this isn't your own biological child that's the
Right.
subject of this case.
Right.
Okay. Then what I'm going to do as a condition of your bond is order that you not have unsupervised contact with all of the children except the one that you're raising. Okay. If you're raising that child, I'll allow you to continue to do that. You'll get out, make sure that you follow all of those bond conditions. The last thing I was going to tell you is that as a condition of this, if you are arrested for anything between now and when you come back for sentencing, again, I don't have to accept this agreement. Things could be worse. You understand? Okay, we'll see you back at sentencing.
Thank you, Your Honor.
Thanks, Judge.
Thank you. It's no contact without supervision except for the 10-month-old. Mr. Lewis, you have a sentencing with Shay Brooks.
Yes, ma'am.
Sentencing. Good morning, are you Shay Brooks?
On the shot.
Shy, and Mr. Brooks, in cause number 24, DCCR 2034, was previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle, received the pre-sentence report. Has everyone had an opportunity to review the report?
Good. Stay here, Judge.
Any additions or corrections?
No, okay.
Nothing stated. The court's already reading the card.
Thank you, sir. All right, Mr. Brooks, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time follow the agreement that you made with the district attorney and find you guilty of evading arrest or detention with the use of a vehicle. Sentence you to a term of 10 years in prison, but probate that for a term of 10 years. You order to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have the felony conviction. Well, no, it's not. I'm sorry. You do have For all practical purposes, your case here in court is over if you do everything you're supposed to. And you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you can be facing that 10-year sentence that you've already agreed to. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir. Thank you. Thank you. Paul McCorvey, Mr. Lewis.
Good morning.
Good morning. And sir, you're Larry Fletcher Jr.?
Yes, ma'am.
And Mr. Fletcher, in cause number 25, DCCR 0838, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from September 18th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
In cause number 25, DCCR 0839, you're charged with the second-degree felony offense of manslaughter from September 18th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years. Do you understand? And then finally, in cause number 21, so we've got a motion to revoke probation in that one. Okay.
What I do is just go through the motions this week. I think Mr. Holman said that he would rather proceed on the MTRP first.
Well, the MTRP is based solely on these allegations.
So it would be a whole trial.
Yeah. Additionally, if the MTRP was adjudicated prior to this case going to trial, arguably it could foreclose an application for probation by the defendant, so.
That, I'm not worried about that, because if it, no, I guess I just don't want to. What level offense is that possession? Hold on a second, let me go back here. Second degree. Where's Mr. Coleman? To get right in. I mean, a lot of times I want to do the motion first, just because it depends on what the allegations are. I don't want to try to have to find 2 days for a hearing and hear all the evidence that we're then gonna have to turn around and potentially hear in a trial if it's not likely to be dispositive. One more thing, hold on. Yeah, on this one, I don't know that makes judicial economy sense. So what I'm inclined to do is set those for trial. But let me do this. It looks like the state has offered you in those 2 cases an 18-year term in prison. Mr. Fletcher, I have a plea bargain rejection that has your signature on it showing that, and that would be 18 years in each of those cases to run concurrently. Is that your understanding of what their offer is? And you understand if you go to trial again and you're found guilty, the range of punishment can be up to 20 years in prison. Do you understand?
Yes, ma'am.
I do want to go ahead and do this, and then let's go through the motion. I do want to get pleas of true or not true on that motion, and then what I'll do, Mr. Wilkerson, is get with you and Mr. Coleman in the next week or so. He's got a trial this week that he's getting prepared for, and I will make a decision on whether or not I'm going to go forward on the motion or if we're going to set those cases for trial first. But I want him to be able to have at least his argument in that, so we'll do it that way. So let me go through and find the motion real quick. And Mr. Fletcher, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Put your hand down. So in cause number, there we go, 21-37809. I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 11th of 2021 for the second-degree felony offense of possession of a controlled substance, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense of manslaughter on September 18th of 2024, and is that true or not true?
Not true.
Count 2 alleges that you committed the offense of criminally negligent homicide September 18th of 2024, and is that true or not true?
Not true.
Count 3 alleges that you committed the offense of aggravated assault with a deadly weapon September 18th of 2024, and is that true or not true?
Not true.
Count 4 alleges that you committed the offense of possession of marijuana on July 4th of 2023, and is that true or not true?
True.
Count 5 alleges that you committed the offense of unlawful carrying a weapon on July 4th of 2023, and is that true or not true?
Not true.
All right, did you enter your plea of true to count 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to that count because it's actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your plea of true to count 4 freely and voluntarily, find that count true, find sufficient evidence to find you guilty and revoke your probation. However, what I'm going to do is reset this for now. Just make a note for me to decide what I'm resetting it to and put it on my desk, and I'll get an email or a call, Mr. Wilkerson, with you and Mr. Coleman within the next couple of days, and we'll figure out if I'm going to set it for a hearing and what amount of time that would need on the motion, or if I'm going to set it for trial on the new cases first.
Okay.
All right? And we'll stay in touch with Mr. Wilkerson and your bondsman, and they'll let you know when you need to be back, and he'll let you know what it's going to be for and all of that.
Yes, ma'am.
Okay? You're free to go. We need a print, please.
And just like that, the judge made it crystal clear. Bond isn't just about money, it's about trust. When you're facing an aggravated assault charge involving a deadly weapon, every prior arrest, every missed check-in, and every broken condition matters. What really changed the room here wasn't just the mother's testimony, it was that jail call. That recording gave the court a deeper look into Jonah's mindset. And in hearings like this, that can be the difference between walking out or staying behind bars. Legally, bond reduction hearings focus on risk. Are you a danger to the community? Are you likely to run? And most importantly, can the court trust you to follow the rules? In this case, the judge's answer was simple: not yet. And now the pressure shifts. The next move could be a plea deal or a full trial. Either way, the stakes just got higher. What do you think? Was the judge right to deny the bond reduction, or should Jonah have gotten another chance? Drop your thoughts below, because this case is far from over.